There's a trap door beneath the marble floors of justice, and the password is simple: too bizarre to be fiction. Welcome to the Shadow Courtroom, where logic bends, juries weep, and the most effective defense isn't evidence, it's weaponized strangeness. 1. The Hypnotic Puppet Master. Can a human being become a remote control car, programmed to kill without memory or consent? In 1951 Denmark, this wasn't philosophy. It was courtroom testimony. A man robbed a bank and executed 2 people, then claimed his former cellmate had hypnotized him into becoming an unwilling weapon. The prosecution scoffed. The defense brought him before the jury and had him hypnotized live, like a magic show at a capital murder trial. The demonstration worked with terrifying effectiveness. The puppeteer received life imprisonment, while the puppet walked away with a drastically reduced sentence. The case established a precedent that still haunts legal scholars. If free will can be overwritten like computer code, where does criminal responsibility actually live? Your mind might be the crime scene, but someone else could be holding the murder weapon. 2. The affluent immune system. Money can't buy happiness, but in 2013, it apparently bought immunity from understanding consequences. Ethan Couch, 16 years old with a blood alcohol level 3 times the adult legal limit, killed 4 pedestrians in Burleson, Texas. His defense team introduced America to affluenza, a condition born when wealth insulates someone so completely from accountability that their moral compass simply never develops. The psychologist testified that Couch's parents had coddled him into incompetence, teaching him that money, not apologies, fixes problems. The judge agreed, sentencing him not to prison, but to probation and a luxury rehabilitation facility. The nation erupted in fury. 4 families buried their dead, while a teenager learned that wealth isn't just power, it's a get-out-of-jail-free card with a designer label. 3. The alien hand conspiracy. Imagine your hand has its own consciousness, its own agenda, and absolutely no interest in consulting you before committing crimes. Alien hand syndrome is a documented neurological disorder where a person's limb operates independently, unbuttoning shirts, slapping faces, even attempting strangulation, while the conscious mind watches in horror. This condition has birthed one of the most surreal defenses imaginable: shoplifting committed by a rogue appendage. Picture standing before a judge explaining that your alien hand grabbed merchandise and stuffed it into your pocket, while your brain screamed objections. In documented cases, defendants have successfully argued that if their own neural circuitry isn't controlling the limb, criminal intent cannot exist. Your hand might be guilty, but apparently you're just an innocent bystander trapped in the same body. 4. The sleepwalking executioner. Kenneth Parks woke up on May 24, 1987, not in his bed, but at a police station, with bloody hands and a confession that sounded like fiction. "I think I have killed some people." He had driven 14 miles to his in-laws' Scarborough home, bludgeoned his mother-in-law Barbara Woods to death with a tire iron, and nearly strangled his father-in-law Dennis. His defense was audacious to the point of absurdity. He claimed he'd been asleep for the entire ordeal. Medical experts confirmed severe sleep disorder, documented history of sleepwalking, and crucially, zero motive. The jury faced an impossible philosophical question. Can you convict a man whose consciousness wasn't present at the crime? Their answer was no. Parks was acquitted of everything. Somewhere in the intersection of neuroscience and justice, he disappeared through a legal loophole the size of a nightmare. 5. The sugar-fueled assassin. November 27, 1978. Dan White crawled through a window at San Francisco City Hall, bypassing metal detectors with cold calculation, and executed Mayor George Moscone and Supervisor Harvey Milk. The murders were methodical, deliberate, political. But in court, White's attorneys painted a portrait of a man unraveled by depression, and their smoking gun was his diet, specifically Twinkies and Coca-Cola. The media dubbed it the Twinkie defense, though the actual argument was diminished capacity. His lawyers claimed the sugar rush wasn't the cause, but a symptom of mental collapse, evidence of a man whose judgment had deteriorated to the point of involuntary manslaughter. The jury bought it. 2 executions became voluntary manslaughter. San Francisco erupted in the White Night riots. Justice tasted sweet for the defendant, bitter for everyone else. 6. The facial prejudice paradox. You're a defense attorney in Italy. Your client is guilty. The evidence is overwhelming. What's your Hail Mary? Argue that your client is too ugly to receive a fair trial. This isn't satire. It's documented legal strategy. A man convicted of molestation appealed on grounds that his unattractiveness inherently biased the all-female court. He claimed they were so repulsed by his appearance that objectivity became impossible. The appellate court agreed, overturned the conviction, and ordered a retrial. Beauty privilege became legal doctrine, establishing that aesthetic disadvantage constitutes procedural injustice. Your face isn't just your identity anymore. It's potential grounds for mistrial. 7. The 24 personalities. Billy Milligan was arrested in the 1970s for serious crimes, but his lawyers argued the man sitting in court was innocent, a hostage in his own body. Milligan had dissociative identity disorder with 24 distinct personalities, and his defense claimed 2 of those alters were the actual criminals. Billy himself, just an unwitting bystander trapped in a crowded consciousness. Extensive psychiatric evaluation convinced the court this wasn't performance art, but genuine fragmentation of identity. He was found not guilty by reason of insanity, becoming one of the first major cases where DID successfully negated criminal responsibility. The verdict raised a terrifying question. If different consciousnesses share one body, which one stands trial? Justice requires a defendant. But what happens when the defendant is plural? 8. The Chewbacca principle. South Park writers created a parody, lawyer Johnny Cochran confusing juries with nonsensical rants about Chewbacca the Wookiee, creating such convoluted chaos that verdicts became impossible. Real attorneys watched and recognized not satire, but documentary. The Chewbacca defense became unofficial terminology for bamboozling juries with irrelevant information, red herrings, and complex jargon when actual evidence isn't cooperative. It's the art of winning by creating intellectual fog so thick that reasonable doubt becomes inevitable. Bury facts under confusion, drown logic in absurdity, and watch as juries surrender to the path of least resistance: acquittal. The strategy works because human brains, when overwhelmed, default to inaction rather than incorrect action. Sometimes the best defense isn't truth, it's terminal bewilderment. 9. The self-kidnapping officer. Michael Dickerson's Florida car chase ended with him refusing to exit his locked vehicle. Officer John Jones, displaying creativity over protocol, popped the trunk and climbed inside, intending to force the doors open from within. At that exact moment, Dickerson hit the accelerator, initiating a second high-speed chase, this time with the police officer bouncing around in the trunk like contraband. When finally apprehended, kidnapping was among the charges. His lawyer's defense was brilliantly simple. You cannot kidnap someone who voluntarily climbs into your trunk. The judge agreed, dismissing the kidnapping charge on grounds that Officer Jones had essentially kidnapped himself through creative incompetence. The law protects you from being kidnapped, but apparently not from your own questionable tactical decisions. 10. The demonic possession gambit. Connecticut, 1981. The Warrens, paranormal investigators who would later inspire horror franchises, performed an exorcism on an 11-year-old boy. During the ritual, family friend Arnie Johnson taunted the demon, inviting it to leave the child and possess him instead. Months later, Johnson stabbed his landlord to death. His attorneys prepared America's first "the devil made me do it" defense. They argued Johnson wasn't in control, that the demon from the exorcism had accepted his invitation and turned him into a puppet of hell. The judge rejected the defense as unprovable, but the spectacle dominated proceedings. Johnson was convicted only of manslaughter, not murder. Whether demons exist remains theological debate, but their usefulness in reducing charges is documented legal history. 11. The PTSD battlefield defense. 2 brothers from a Washington, D.C. neighborhood where violence wasn't occasional, but atmospheric, shot a man they perceived as a threat. Their 1994 trial didn't argue traditional self-defense. Instead, their lawyer presented urban survival syndrome. Growing up witnessing murders and constant threats had rewired their brains, conditioning them to react with preemptive force like soldiers in a war zone. They weren't acting from malice, but from deeply ingrained battlefield mentality, a form of PTSD where survival calculus overrides civilian morality. The jury was profoundly moved. While not fully acquitted, the defense successfully reduced murder to manslaughter. Their environment didn't excuse the violence, it just explained why their brains treated suburban streets like combat zones. 12. The indistinguishable livestock gambit. A man was accused of stealing a valuable sheep flock. Evidence was strong. Conviction seemed certain until his lawyer brought actual livestock into the courtroom. He presented a single sheep that looked identical to the stolen ones, then challenged the accuser to definitively identify his property. The owner, flustered, admitted he couldn't be 100% certain. The lawyer turned to the jury. If the owner can't even identify his own sheep, how can you be sure beyond reasonable doubt? The case was dismissed. The defense weaponized biological similarity, transforming the prosecution's burden of proof into an impossible task of distinguishing identical animals. Sometimes the best legal argument is simply, all sheep look the same, delivered with enough theatrical confidence. 13. The medieval duel demand. In 2002, a 60-year-old UK mechanic received a minor traffic fine and responded by slamming a gauntlet on the courtroom table, demanding trial by combat. This wasn't cosplay. He'd discovered the medieval law allowing duels had never been officially abolished. He formally challenged the driver and vehicle licensing agency to battle using samurai swords, Gurkha knives, or sledgehammers. The court was stunned, adjourning to determine if this ancient right remained legally valid. He ultimately won, not by fighting, but because the system found dropping the $25 fine easier than confronting the legal paradox he'd created. Bureaucracy surrendered to the threat of litigation by broadsword. Medieval law is like malware in the legal code, dormant for centuries but still executable under the right conditions. 14. The cultural collision defense. A Hmong immigrant from Laos was charged with kidnapping and assault in the 1980s. His defense? He was performing Zipoi Neum, a traditional courtship ritual that resembles abduction to Western eyes. His lawyers argued he had no criminal intent. He was simply following cultural customs he'd always known, operating under a completely different social operating system. The court, recognizing the immense cultural gap, showed leniency, allowing him to plead to lesser charges with minimal sentence. The case highlighted a fundamental legal question. When different cultures define consent, violence, and courtship differently, whose definitions govern? Justice requires shared understanding of what constitutes a crime. But what happens when that understanding isn't shared at all? 15. The internal brewery defense. Auto-brewery syndrome sounds like science fiction. Yeast overgrowth in the gut fermenting carbohydrates into ethanol, turning bread and pasta into alcohol inside your digestive system. People with this condition can become legally intoxicated just by eating. This created the ultimate DUI defense. Arrested, blowing 0.20 on a breathalyzer, swearing sobriety, and having doctors confirm your body is a secret distillery. It's involuntary intoxication in the most literal sense, not a spiked drink, but a hijacked metabolism. In multiple documented cases, DUI charges were completely dismissed once the condition was diagnosed. The law criminalizes choosing to drink and drive, but how do you prosecute someone whose biology makes that choice for them? Your gut bacteria might be brewing beer without your permission, and apparently that's a valid legal defense. 16. The hypoglycemic rage defense. A UK man committed violent assault in a fit of rage. His lawyer didn't argue insanity or self-defense. Instead, he claimed severe hypoglycemia triggered by binging on sugary snacks. An expert testified that dangerously low blood sugar could cause aggression, confusion, and complete loss of self-control. Essentially, the brain being starved of fuel. The court was persuaded he wasn't criminally responsible for actions committed while his brain was in metabolic crisis. He was acquitted, all thanks to soda and chocolate bars. The verdict established that biochemical catastrophe can negate mens rea, the guilty mind required for conviction. Your blood sugar isn't just a health metric. It's potentially the difference between assault and medical emergency. 17. The video game nightmare defense. A Welshman was found in a stranger's home, seemingly mid-burglary. His explanation? He was having an intense nightmare about being in a video game and was acting out the dream. It sounds ridiculous until medical experts testified he had severe parasomnia, a sleep disorder where the brain's off switch for physical movement during sleep fails. His mind was asleep, but his body was awake and on autopilot, executing dream commands in physical reality. The jury was convinced he had no conscious control. He was acquitted. The case validated that consciousness is not binary. There are states where the body operates while the mind remains offline. Sleepwalking into someone's home isn't burglary if your consciousness never left the dream world. 18. The 500-year-old vampire defense. A Texas man arrested for assault didn't claim insanity or innocence. He claimed to be a 500-year-old vampire requiring human blood for survival. During trial, he maintained this belief with unwavering consistency. The psychiatric evaluation confirmed profound delusion. He genuinely inhabited a different reality where his identity, needs, and moral framework were fundamentally inhuman. The jury found him not guilty by reason of insanity, presumably because legal jurisdiction doesn't extend to the undead. The verdict acknowledged that criminal law requires a shared understanding of reality, and when that shared understanding completely fractures, conviction becomes philosophically impossible. Justice requires a defendant who understands they're being tried, not one who believes courtrooms are mortal rituals irrelevant to vampires. 19. The rotten social background defense. First proposed in the 1970s, this defense argues that upbringing so filled with poverty, abuse, and neglect can prevent proper moral development. The lawyer argued society itself was co-conspirator in the defendant's crimes by allowing toxic childhood conditions. While never leading to full acquittal, it has successfully convinced juries to choose manslaughter over murder. The defense doesn't excuse violence, but contextualizes it, arguing that moral culpability requires having had genuine opportunities to develop morality. It's the legal equivalent of arguing you can't be punished for failing a test you were never taught to take. Your childhood doesn't absolve you of crime, but apparently it can reduce your sentence by several degrees of murder. 20. The evil twin loophole. Identical twins create a factual nightmare for prosecution. Criminal trials require proving beyond reasonable doubt that the specific defendant committed the crime. But if eyewitnesses saw one of them and forensic evidence matches both brothers, the entire system short circuits. This isn't psychological defense, but factual impossibility. Authorities literally cannot definitively prove which identical sibling is the culprit. In several real cases, charges from theft to more serious crimes have been dropped simply because twins exist. It's the ultimate alibi, being born with someone who shares your DNA. Justice requires identifying the guilty. But what happens when biological identity comes in duplicate? 21. The Matrix simulation defense. Tonda Ansley shot and killed her landlady in Ohio, arguing she wasn't murdering a person but freeing herself from the Matrix's control. The Wachowski siblings' film wasn't just entertainment for Ansley. It was documentary evidence that reality is computer simulation, and killing within that simulation lacks moral weight. The jury found her not guilty by reason of insanity, essentially agreeing she genuinely believed reality was fabrication. The case represents life imitating art, imitating philosophical thought experiment. Defendants using cinematic fiction as framework for delusion. The legal system doesn't rule on whether we live in a simulation, only whether defendants believe we do. Your perception of reality might be psychosis, but if it's genuine psychosis, apparently that's sufficient defense. 22. The premenstrual syndrome defense. Sandy Craddock, a British barmaid with extensive violent history, stabbed a coworker to death in the 1980s. Her defense team argued she wasn't a murderer, but a victim of cripplingly severe premenstrual syndrome triggering diminished responsibility. A doctor testified her hormonal imbalance was like a boiling pan with the lid on. The court was persuaded. Her murder charge reduced to manslaughter. Sentence reduced to probation contingent on hormone therapy. The verdict validated that hormonal fluctuations can constitute medical mitigation for violence, transforming what was often dismissed as punchline into legitimate legal defense. Biology isn't destiny, but apparently, monthly hormonal cycles can reduce murder charges by 1 degree. 23. The insufficient anatomy defense. A Washington man was charged with indecent exposure. Evidence seemed clear. His defense was so bizarre it left the courtroom speechless. His lawyer argued the defendant's endowment was so minuscule it couldn't possibly meet the legal definition of exposure. The jury, after what must have been the most awkward deliberation in legal history, found the argument compelling and acquitted him. The case established that criminal statutes have minimum physical thresholds, and measuring whether those thresholds are met can become evidence. Sometimes the best legal defense is anatomical insufficiency, delivered with enough straight-faced confidence to survive jury scrutiny. 24. The devil can't dance defense. 17th century France. A woman was accused of witchcraft, with primary evidence being that she'd been seen dancing with the devil at a witch's sabbath. Her lawyer deployed pure theological logic. For his client to have met the devil must exist. But if the devil exists, he's a fallen angel, a spiritual being incapable of physical dancing. Therefore, the star witness's testimony described a physical impossibility. This theological loophole defense was so perfectly reasoned within contemporary beliefs that the court was stumped. The case collapsed and she was freed, not by denying witchcraft, but by proving the devil had 2 left feet. Sometimes the best defense isn't disproving accusations, but demonstrating they violate the very theology used to justify them. 25. The perpetual mime defense. A New York street performer arrested for aggressive panhandling in 2012 refused to speak when questioned. He didn't invoke Fifth Amendment rights, he simply continued his mime act, pretending to be trapped inside an invisible box. He maintained silent artistic protest throughout his entire arraignment, frustrating the judge, prosecutor, and court officers. Ultimately, the judge dropped charges because conducting legal proceedings with a defendant who is, for all intents and purposes, a living silent work of art proved impossible. The case validated that the right to remain silent can be performed as literal theater. You have the right to remain silent, and apparently that right extends to remaining a mime throughout criminal proceedings. 26. The involuntary sneeze acceleration. A Swiss driver was caught on camera going well over the speed limit. The case seemed open and shut until his lawyer presented sneeze-induced acceleration. He argued his client was struck by sudden violent sneezing fit just before the speed camera, causing involuntary leg spasm that pressed the accelerator. Medical experts testified such powerful involuntary reflex was indeed possible. The court found the explanation plausible and acquitted him. The verdict established that biological reflexes can negate criminal traffic violations. Your body betraying you constitutes legal defense. Apparently I sneezed is sufficient explanation for speeding, provided you can find medical experts willing to testify about convulsive leg movements. 27. The bee sting automatism. A woman was driving when a bee flew into her car and stung her, causing panic, swerving, and crash into another vehicle. She was charged with reckless driving. Her lawyer argued the sudden sharp pain triggered involuntary reaction, automatism, not conscious choice. The judge agreed her response was uncontrollable reflex, dismissing charges. The case validated that sudden medical events creating involuntary reactions negate the voluntary component required for traffic violations. You're only guilty of reckless driving if you consciously chose recklessness. When a bee weaponizes itself against your ability to drive safely, apparently that's the bee's fault, not yours. 28. The coffin maker's paradox. Medieval France. A convicted coffin maker was sentenced to hang within 24 hours per legal requirement. When the executioner came, the coffin maker refused, arguing he was the only coffin maker in town and hadn't yet built his own coffin, which was his right. Because he couldn't build it within the 24-hour deadline, the execution couldn't legally proceed. Officials were so stumped by this logical paradox, they released him. He weaponized his professional monopoly against his own death sentence, creating an infinite loop bureaucracy couldn't resolve. Sometimes the best escape from execution is creating a logic puzzle the legal system lacks administrative capacity to solve. 29. The giant spider hallucination. Joel Lowe woke up in Manchester and began brutally attacking the woman in his bed, believing she was a giant threatening spider. When police arrived, he was still in terror, fighting an imaginary creature. His defense? Hypnagogic hallucination, a terrifyingly vivid dream state bleeding into reality upon waking. He wasn't attacking a person. In his mind, he was fighting for survival against a monster. A sleep expert confirmed the condition was real. The court found him not guilty, concluding his brain committed the crime without conscious participation. Your brain can commit assault while you're still technically asleep, and apparently that constitutes valid defense. 30. The lemon juice invisibility theory. In 1995, MacArthur Wheeler robbed 2 banks in broad daylight without a mask. When police showed him security footage, he was genuinely shocked. He'd covered his face in lemon juice, believing it would make him invisible to cameras like invisible ink. This wasn't insanity plea, but profound, baffling mistake. His sheer incompetence became cornerstone of what psychologists now call the Dunning-Kruger effect. Being too incompetent to recognize one's own incompetence. He wasn't acquitted, but his case became legendary example of stupidity so pure it transcends criminal intent. Sometimes the best defense isn't intelligence, but demonstrating such spectacular lack thereof that mens rea becomes questionable. 31. The amnesia limbo. You wake in jail with no memory of yesterday. Police say you committed terrible crimes, but to you, yesterday is complete blank. The amnesia defense doesn't argue innocence, but incompetence. Defendants with genuine amnesia cannot meaningfully assist in their own defense, cannot offer alibi or challenge prosecution's narrative. In many cases, this doesn't lead to acquittal, but results in trial being postponed indefinitely until memory returns, leaving defendants in strange legal limbo. The legal system requires defendants capable of participating in their own defense. But what happens when memory loss makes that impossible? Your memory might be the key to your trial, but if you've lost the key, apparently the trial can be suspended forever. 32. The portable toilet heist. At an Australian music festival, a man faced endless lines for portable toilets. He saw opportunity. Not an open toilet, but a temporarily occupied one. Undeterred, he grabbed the entire plastic outhouse and began dragging it away with a confused, terrified person still inside. When police caught up, his defense was absurd logic. It wasn't theft, but emergency relocation. Desperate problem solving because the line was too long and biological need too great. The judge, faced with one of the most ridiculous cases ever, saw the human side and let him off with stern warning. Kidnapping someone inside a portable toilet isn't really kidnapping if you're just trying to skip the line, apparently. 33. The patriotic rage defense. In 1859, New York Congressman Daniel Sickles discovered his wife was having an affair with District Attorney Philip Barton Key, son of the man who wrote the Star-Spangled Banner. Sickles confronted Key across from the White House and shot him dead in broad daylight. At trial, Sickles' defense team pioneered temporary insanity, arguing the affair's dishonor drove him into patriotic rage. It was the first time this defense succeeded in the United States. The jury set him free, establishing precedent that emotional extremes can temporarily negate criminal responsibility. Apparently, murdering your wife's lover in front of the White House is forgivable if you're sufficiently outraged about family honor. 34. The parrot witness. In 2015, Martin Durham was killed in his home. Police had few leads until they listened to Bud, the victim's African gray parrot. The bird kept repeating in what sounded like the victim's voice. Don't fucking shoot. The prosecutor seriously considered putting the parrot on the witness stand. While a judge ultimately didn't allow it, the parrot's testimony was so compelling and widely reported, it heavily influenced the case against the man's wife, later convicted of murder. Birds cannot testify, but apparently they can mimic last words convincingly enough to influence murder convictions. 35. The too fat for prison defense. A UK man weighing nearly 500 pounds was sentenced to prison time. His lawyer didn't argue innocence, but argued imprisoning him would be potential death sentence. The man's severe obesity and complex health problems requiring specialized equipment, strict diet, and constant medical monitoring were beyond what prison systems could handle. Sending him to jail would constitute cruel and inhuman punishment, guaranteed medical neglect by the state. The judge faced a dilemma: uphold the sentence and risk a man's life, or find another way. The man was quite literally too fat for prison. His sentence was commuted to house arrest. Your physical reality can fundamentally break the justice system if you're heavy enough. 36. The water intoxication defense. A woman began acting erratically and committed assault with no history of violence or mental illness. Her lawyers discovered she was on extreme health diet, requiring gallons of water daily, inducing hyponatremia, dangerously low sodium levels, causing brain swelling, confusion, psychosis, and complete loss of control. The court accepted she was in delirium and not responsible. The verdict established that even beneficial substances consumed in extreme quantities can negate criminal responsibility through medical catastrophe. Drinking too much water can turn you into a temporary criminal, and apparently that's legitimate defense. 37. The killer bee necessity. A couple hiking in Arizona accidentally disturbed a massive Africanized beehive and were relentlessly pursued. Fearing for their lives, they broke into a nearby empty cabin to take shelter. The owner pressed charges for breaking and entering. Their lawyer used necessity defense. Breaking the law was the only way to prevent greater harm, in this case, gruesome death. The judge agreed, ruling any reasonable person would choose misdemeanor over being stung to death. Charges were dropped. Trespassing is illegal unless killer bees are chasing you, in which case it's survival and the law understands. 38. The football grief arson. A diehard Green Bay Packers fan was so distraught after the rival Minnesota Vikings beat his team that he went to his Vikings-loving neighbor's house and set the garage on fire. In court, his lawyer argued he was suffering from extreme emotional disturbance brought on by devastating loss. Not arson, but temporary break from reality fueled by football. While not completely exonerated, the argument was compelling enough for a jury to convict him of significantly lesser charge. The verdict validated that sports fandom can reach intensities that mitigate criminal behavior. Apparently, burning your neighbor's property because your team lost is slightly less criminal if you're really upset about football. 39. The exorcism self-defense. A man was found violently attacking a friend or family member. To witnesses, it was clear assault. But the man's story: he wasn't attacking his loved one at all. He was fighting a demonic entity possessing their body. In his mind, he wasn't criminal, but hero, reluctant exorcist in desperate battle against evil. When psychiatric experts testified the defendant was experiencing genuine psychotic delusion and was truly incapable of perceiving reality correctly, this defense worked. The court doesn't rule that demons are real, only that the defendant's belief in them was, and that belief erased criminal intent. You can't be guilty of assault if you genuinely believed you were performing an exorcism, apparently. 40. The government manufactured crime. The entrapment defense argues defendants only committed crimes because they were tricked, coerced, or persuaded by law enforcement. The most famous example, automotive executive John DeLorean's trial in the 1980s. The FBI, using an informant, lured him into a massive fake illegal deal, filming everything. Evidence looked damning, but his lawyers successfully argued the government essentially manufactured the entire crime from scratch. DeLorean would never have done it otherwise. The jury agreed. He was acquitted of all charges. If the government has to create the crime to catch you committing it, apparently you're not really guilty. 41. The Jedi Knight defense. In 2011, Oregon police were called to deal with a man wildly swinging a plastic lightsaber, attacking random cars and shoppers in a parking lot. When arrested, he calmly explained he was a Jedi Knight practicing combat forms against Sith hiding in plain sight. This wasn't a joke. His lawyer successfully used this as foundation for insanity defense, arguing his client lived in a Star Wars fantasy so complete and immersive, he was incapable of distinguishing between suburban parking lot and galactic battlefield on Coruscant. He was found not guilty by reason of insanity. Believing you're a Jedi isn't a hobby. It's a valid insanity defense if you commit assault with a toy lightsaber. 42. The genetic predisposition defense. Stephen Mobley was convicted of murder in the 1990s. During his appeal to avoid the death penalty, his lawyers argued Mobley wasn't entirely to blame. He carried a specific genetic variant, a mutation in the MAOA gene, linked in studies to aggressive and impulsive behavior. They weren't saying he was innocent, but that he was biologically predisposed to violence, a prisoner of his own genetic code. While this specific appeal was ultimately denied, it blasted open a Pandora's box in courtrooms worldwide, forcing the legal system to grapple with where free will ends and biological destiny begins. Your DNA might be your accomplice, and the legal system is still figuring out how to prosecute that. 43. The post-lunch theft defense. A British man was caught red-handed stealing significant cash from his employer. His lawyer argued he wasn't a thief. He was simply sleepy. The official defense, postprandial drowsiness, the scientific term for the body's natural slowdown after large meal. A doctor testified the man suffered from unusually severe form of this condition, causing profound disorientation, confusion, and susceptibility to poor judgment. The court accepted he was not in rational state of mind when he took the money. Incredibly, he was cleared of charges. Food coma is apparently legitimate alibi for theft if you can find a doctor willing to testify about your exceptional drowsiness. 44. The spider phobia inferno. A North Carolina woman watched her car go up in flames. The insurance company was convinced it was arson and fraud. Her defense? Arachnophobia. She testified with genuine terror that while driving, she spotted a large spider crawling inside the car. In blind panic, she slammed brakes and leaped out of the moving vehicle, watching in horror as her driverless car rolled down a hill, crashed into an embankment, and caught fire. She didn't burn the car, a spider scared her into a freak accident. The jury found her testimony believable and acquitted her of all charges. Apparently, total the car to escape a spider, and that's not insurance fraud, it's just spectacular arachnophobia. 45. The chronic hiccup alibi. Charles Osborne holds the Guinness World Record for longest continuous hiccup attack, 68 years from 1922 to 1990. In the 1930s, Osborne was put on trial for murder. The prosecution's case hinged on testimony from a single witness claiming Osborne confessed the whole crime to him. But Osborne's lawyer presented defense so specific, it could only apply to one man on Earth. The chronic hiccup alibi. He argued his client, who hiccuped violently up to 40 times a minute, was physically incapable of speaking a coherent sentence, let alone detailed murder confession. The jury found the confession medically implausible. Charles Osborne was acquitted. If you hiccup every few seconds for 68 years, apparently you can't confess to murder because nobody could understand you anyway. 46. The literacy salvation verse. For centuries in England, your best defense for serious crime wasn't alibi or witness. It was ability to read a single Bible sentence. The benefit of clergy was one of history's most bizarre legal loopholes. Originally intended for clergymen, it evolved into get-out-of-jail card for anyone literate. A convicted criminal, even one sentenced to death, could claim this benefit. The court would present a Bible open to Psalm 51:1, the neck verse. If the convict could read it aloud, they'd be spared execution, branded on the thumb, and set free. It was life or death literacy test, and countless criminals spent jail time desperately memorizing that one verse to save their necks. Being able to read didn't make you innocent, it just made you exempt from hanging. 47. The dog was driving defense. In 2003, a Washington state man crashed his car into a telephone pole. When police arrived, he confidently explained what happened. His dog, a pit bull mix, was driving. He claimed he was merely teaching his beloved pet how to operate a vehicle. Police didn't buy it for a second and charged him with DUI. Though not a full acquittal, the sheer audacity of this defense in court setting is masterclass in creative desperation. The story itself is a legal Hall of Famer. Blaming your dog for drunk driving is not a valid legal defense, but it is an immortal example of spectacular excuse-making. 48. The alien juror technicality. Picture 19th century American courtroom. A man is tried for murder, found guilty, sentenced to hang. Justice served. Years later, shocking discovery. One juror was not a U.S. citizen or even legal resident. The entire case was appealed on grounds the jury was improperly constituted, making the verdict legally null and void. In several real historical cases, this alien juror defense successfully overturned murder convictions. Not because of new evidence or innocence claim, but because of single unnoticed bureaucratic error invalidating the entire trial from the beginning. One non-citizen on your jury can undo your entire murder conviction years later through pure technicality. 49. The secondhand smoke DUI. A man was pulled over and failed a sobriety test despite swearing he was sober. His defense: his car was so thoroughly hotboxed by his passengers that he'd become passively intoxicated just from breathing the air. While it sounds like a desperate excuse, he had a scientist testify it was theoretically possible. This defense has been used successfully in several cases to have charges dismissed, proving sometimes you really can get contact high. The legal system distinguishes between choosing intoxication and having it imposed on you by your car's atmosphere. Apparently, you can get a DUI without drinking or using drugs if your friends create sufficiently toxic air quality in your vehicle. 50. The shopping addiction embezzlement. Stephen Wrights was a Florida lawyer caught embezzling hundreds of thousands of dollars from clients. Evidence was irrefutable, career-ending. But Wrights, representing himself, argued he suffered from rare condition forcing him to do it: shopping addiction. He claimed uncontrollable pathological compulsion to buy expensive luxury goods. Uncontrollable pathological compulsion to buy expensive luxury items. Stealing from people who trusted him was the only way he could fund his illness, he argued. He was essentially claiming he was the real victim, a victim of his own lavish lifestyle and exquisite taste. The sheer audacity of a lawyer using self-diagnosed, luxury-based addiction to excuse financial crimes is perfect, almost beautiful encapsulation of the human brain's limitless capacity for self-serving justification. While the defense didn't fully succeed in avoiding consequences, the argument itself represents the absolute pinnacle of blaming your problems on anything but yourself. When theft becomes illness and embezzlement becomes symptom, we've reached the event horizon of legal absurdity. 50 cases where absurdity defeated evidence. Sleepwalkers acquitted. Twinkie defenses reducing murder. Hands acting independently of consciousness. Medieval combat demands dismissing traffic fines. Parrots nearly testifying. Defendants claiming Jedi Knight status. These aren't loopholes. They're proof that justice bends when logic meets weaponized strangeness. The courtroom operates on certainty, but certainty is luxury the human condition rarely provides. Somewhere, right now, someone is preparing the 51st defense, and it will be too bizarre to be fiction.